My name is Ana Aliverti. I am a professor of law. Welcome to my exp. The term crimmigration has been coined in the beginning of the 2000s by an immigration scholar, Juliette Stampf, who works in the US and has been very influential for understanding, particularly in the US, how criminal law tools are being used to control migration. And we talk about criminalization and the use of criminal law specifically to deal with migration breaches. But she also talks about how, for instance, the prison and the logic of the prison is also increasingly a way of dealing with migrants, and how migration controls have been increasingly taking on the practices, the logics of criminal law and criminal justice without the migration, in a sense, of the safeguards that are very much in a criminal justice process. So crimmigration means this migration of criminal law into immigration law and immigration law into criminal law, but creating a second-class system of justice where safeguards and rights and protections that are germane to the criminal justice process are not migrated with it. There are a number of implications of this intersection of criminal law and migration law. For instance, and this is something that I have been looking at empirically in the context of the UK, of how migrants are dealt with in the criminal justice system, not just for migration related offenses, but more generally. And so, for instance, we see that questions of interpretation are a problem. So people are not provided with the right service in terms of understanding and being able to participate in the criminal justice process. We also documented how migration status is and the potential deportability of someone has significant bearing on sentencing, meaning that people who are due to be deported, potentially deported, are less likely to be given a non-custodial sentence. And that shows in statistics about prison population where we see, particularly in European jurisdictions, an over-representation of foreign nationals in the prison. My work has been tracing how increasingly the criminal law makes people criminal for various immigration breaches. And what I have found, precisely because of this approach on the terms of the law, on formal criminalization, what criminal theories call formal criminalization, is that while the criminal law has, particularly in countries in Anglo-America, where there has been a tradition of using or overusing criminal law to deal with a range of social issues, including migration. There has been an increase in the last few decades of criminal offenses to deal with migration, but that those offenses are not frequently applied. So one of the conclusions that I reach is that the function of criminal law is very much what criminologists or sociologists of punishments call prevention and deterrence, right? Is that symbolic acting out to prevent people from crossing borders illegally. But in practice, that laws are seldom enforced and are enforced in very specific situations. So there is a level of pragmatism in the substantive criminalization that is in enforcement of these laws. The most important misconception is in relation to migration and crime is the fact that migration is problematized, is criminalized, while the human species, if not non-human species, are migratory species by nature, right? So our world has been built around migration and movement. And so what is unique of perhaps our contemporary world is that pathologization of migration, which is built on a range of misconceptions. For instance, that migration brings crime, and we know for a fact that a range of research, criminological research in various jurisdictions have not found a clear link between migration numbers and crime rates and increases in crime rates. So it's important for researchers to push back on the myths through which these policies and these courses are built.